Let me deal with the question which has been raised, that there is animosity between Mr. Isaac and myself. I want to tell the court, these are personal matters, but they have been raised by the respondents, that Isaac and I are very close friends. We respect each other. During the last 2 years, we have collaborated with the Commission at the request of Mr. Isaac. We have assisted the Commission in developing ideas and provisions for the effective representation of women. At his request, we invited a leading vision expert to come, and we had a meeting in Nakuru, Nairobi, which Mr. Isaac told me was one of the most fruitful meetings that the Commission has had.
Net result of all this, my lords, is that Katiba Institute does not wear what you would consider to be an objective or neutral face. They come with stated agenda, with stated positions, with stated interests. And I think that consistent with the decision that you gave yesterday as far as the LSK is concerned, they should be similarly debarred from coming in as amicus. They have stated that they have previously been admitted as amicus in other proceedings. They may well have been deserving in the particular context of those cases, but for this particular case, the circumstances clearly indicate that they would not qualify.
For a person like that to come and apply to be an amicus curiae without disclosing the content of his views regarding the parties that are already in the proceedings is wrong. There was a duty on him to make a frank and candid disclosure of the kind of attitude or views that he holds regarding the parties that are already appearing before you. And once it emerged that he holds views that are against any of the parties, then immediately the court would have refused to allow him to come in as amicus. So the fact of failure to disclose the extent to which they have been involved in making comments about the character and the conduct of the elections by itself disqualifies them from being admitted as amicus curiae. Now, my lords, apart from what we've said regarding the articles, if you look at Article 22, which then talks about the right of an institution or an individual to be admitted as amicus curiae, it is very clear that it must be on the basis of a special knowledge of some law. There must be something special that you're bringing into the proceedings. Now, all that Katiba has said is that they are knowledgeable on the provisions of the Constitution. My Lord, everyone that is appearing before you today, including the Honorable, the Attorney General, and all the lawyers that are sitting before you, do nothing else but deal with questions about the interpretation of the Constitution. There is nothing outside the reading of the Constitution and the interpretation of the Constitution that has been put before you that is unique insofar as Katiba is concerned.
Another engagement from somebody coming as amicus curiae would be very unfair. Let us limit the engagement to our political opponents, and my lords will find that actually quite a number of comments here are the same comments that the third and fourth respondents' political opponents routinely talk about. ICC, integrity issues, and all those things. My lords, by this article and many of like nature, Katiba cannot be considered as a friend of the court. Katiba is an opponent to the third and fourth respondents. Regrettably, they did not file a petition, which we could have engaged them on, and it's on that basis, my lords, that I would request you not to allow them.